Hugh Kennedy, to what extent is this a criminal code? And again, could you give us some examples? I mean, there are lurid examples that drift to the West. Can you just...
Traditional Islamic law is very little concerned with criminal law.
Nor is it to some extent, and what is that?
It is to some extent. There comes a consensus about punishments for adultery, punishments for theft, and so on. But in terms of what the lawyers are talking about, these are quite marginal. They're much more interested in
They're quite dramatic, aren't they? I think we must...
yes, they can be quite dramatic, certainly. I mean, in terms of floggings and in terms of executions of one sort or another and amputations of the hands for theft and so on. But as I say, in terms of the intellectual debate, this is not really what lies at the centre of it. Perhaps I could just give you an illustration about how the sort of problems that Muslim lawyers do talk about, and that is about the drinking of alcohol. If you're sitting in your house and you become aware that your next-door neighbour is drinking alcohol, what should you do about it? Now, the lawyers don't talk about, you should go to the police and have the place raided. That's because the state is not a player here. The question is, should you go into your neighbour's house and berate him and smash his wine jars, or should you not? And there's one body of opinion which says, yes, you should, because he's violating Muslim norms. But then you come up against an equally important Muslim norm, is that the house is sacred, in a sense. It is wrong to go into another person's house because you might find his women in a state of undress, and it's his private property and so on. And so the consensus of law is that you shouldn't take direct action to smash up the wine jars. You should remonstrate with him in the street for sure. But there is a balance of obligations here, the obligation of public enforcement against the obligation of privacy.
And the other thing to bear in mind is that the dramatic punishments that one finds stipulated within the Quran, in the juristic literature, in the legal literature, are given an enormously high evidential bar. For example, the punishment for adultery is severe, stoning to death if you're a married person engaged in adultery. But the evidentiary bar, what the evidence which is required in order to carry out that punishment, is for people who actually see the act happening and witness it. And this is a highly unlikely circumstance to take place. And I believe the jurists are building in a whole series of caveats. They have a rule which they can't get rid of, but they're building in all sorts of caveats because they recognise the dramatic and almost barbaric nature of the punishment for adultery as stoning to death. So they build in a very high evidentiary bar, which means that in effect, the punishment becomes theoretical for them. It becomes a theoretical punishment, and this is the same is true for nearly all of these dramatic punishments: the amputation of the hand for theft and the lashes for alcohol. They are, as Hugh has just been laying out, in order for these punishments to be carried out, the jurists devised a system whereby they would only be carried out in extreme circumstances and with a wealth of undeniable evidence.
Mona, briefly, I'm afraid, can you just tell us something of the institutions of classical Sharia? We've heard the codes. How is it put forward in practice, or put into practice?
It's very difficult to know exactly the kind of beginnings of when law became more institutionalised and in what form that reflected itself. People have talked about even the schools of law, the madhahib, as being something that is that took on much a later stage. And actually, what was really happening was that people of a certain people who followed a certain school had just actually attributed the name of that person or that person who was the founder of the school. The four schools themselves,
no, I've talked about the institutions. What were the institutions? Were they courts?
Well, the courts are where the law is put into practice. That's not an institution. But where actually you could learn the law, where you could teach the law, that's actually quite difficult to ascertain. And some have argued that there might be analogous to the Latin Christendom guild kind of institutions, colleges of higher learning. But again, that is much later, and it's very difficult to process actually the formative period. How did that translate from people aspiring to become devotees or disciples of former jurists into institutional practice?
Hugh, was there a sort of permanent is there a permanent feeling about the law by about the 10th century? Has it changed much
Yes,
since then?
it becomes established in a
has
series
it changed
of...
much over the last 1,000 years in all that?
No, but what has changed is people's attitudes to it, and particularly the role of the state as an enforcer of law, which is almost non-existent amongst the early jurists, becomes much more important in later years, and particularly from the Wahhabi period in the 18th century onwards. So what starts off as much more a personal and religious law has in some cases been seen as a state law which should be enforced by state mechanisms, but that is quite... In most areas, that's quite a modern development. And we know very little about what goes on in early times, but I'd just like to finish up perhaps with following on from something that Robert just said, that in the whole of my reading of Islamic history, I have never found any example of stoning to death by adultery being recorded in any historical text. Maybe I just haven't read enough, but that's the position.
I doubt that. Thank you very much, Mona Siddiqui, Hugh Kennedy and Robert Gleave.